Hi, good afternoon, everyone. Welcome to week 8 of Principles of Commercial Law. Really great topic this week. I mean, they're all great, but this one's a one that is people have no troubles seeing the practical relevance to their lives. It's one that will you'll throw around at least once, regardless of whether you're practicing in law or not. It's of course Australian consumer law and consumer protections. It's one that hopefully you will have touched on in contract law at least, but we take another look at it this time around. And now that you're in a third year unit, apply a fresh level of nuance and critical analysis to the topic. Before we get underway, I've just been asked a question about the exam and exam preparation. A few weeks ago, I did promise that I'd provide sort of an example of what an answer or a letter of advice might look like. Now, as we've discussed, that the exam's moving to more of a memo format, I'll shift that slightly. So what I'm going to do next week is, after the tutorial, I'll put out an example answer based on the tutorial problem that will cover the kinds of things that you'd be talking about for a competition law question, but that will also give you a sense of the structure and the way that you can convey your understanding in that internal memo format. So that's something to look forward to as well. And of course, I think I talked about this last week, but if not, under the week 12 tile in Moodle, I've got a practice exam question as well that's based on a previous assessment question. It's still a slightly more complicated than the scenario that you'll be given in the exam, but I think it's really good practice for identifying issues and thinking about how different elements of legal rules can stack on top of one another. So if you haven't seen that already, check it out. And then as we progress through the weeks, as you build up more knowledge in the area, you can dive in and have an attempt of that one. Any other questions before we get started? No? Fantastic. Alrighty. So this week, as I said, we're talking about Australian consumer law. And in some ways, you can really think about this topic as an extension from our week 3 sale of goods discussion, with a couple of caveats. The most important one being that the Australian consumer law applies to, let's say, a more restrictive class of people, in that it only applies to consumers as defined under the Act. But with that slightly refined and narrowed scope comes with it a broader and a way of protecting consumers that extends beyond what you'd expect to see in the Sale of Goods Act. So doesn't apply to as many people, but arguably offers them better protection and does more things for them. So when we're thinking about the ACL and answering hypothetical problems that relate to the ACL, for one, you'll probably find it reasonably easy to identify on the surface what's going on, in that you'll spot, someone's buying something. Maybe I should think about the consumer law. That's something that people don't often miss. But when it comes to being methodical about thinking about, okay, how do I actually structure my thinking and structure my answer to the question, you'll want to have a good maybe template structure or sense of the different elements that you want to be talking about. So for one, as a threshold issue, being able to discuss and define who the Australian consumer law applies to. So understanding that you need goods or services, understanding what what a consumer is, and pulling in these ideas around it's got to be less than $40,000 with some exceptions, all those ideas, building in something of an answer that you can plug into an exam question that deals with all those sort of early threshold issues is a good place to start, because it means that in the exam context, you're not having to spend too much time just sort of working through those preliminary matters. Obviously, you've got to think about, okay, in this particular scenario, are the criteria met? But it just sort of frees up your mind to think about other things. But then from there, we've got a range of different provisions and protections to be thinking through. And the list itself is quite extensive. So what I'd suggest to you in developing your notes is to come up with a way that makes sense to you, most importantly. So I'm not going to dictate exactly what those notes should look like, but come up with a way that makes sense to you of the, depending on the facts, depending on the scenario, what are the types of protections that might be most relevant. So we spent most time in the lecture looking through and talking about misleading and deceptive conduct. So, you know, I would very much make sure that you've got those ideas down pat and being able to identify that. And we'll talk through that in a moment with our hypothetical questions. But then beyond that, when we think about the different some of the other protections, whether that's unconscionable conduct, whether that's unfair practices or unfair contract terms, having some sense of what they are so that in an exam scenario you can very quickly just check the detail of each, I think is a really good approach, because it's, unless you dedicate an insane amount of time to this topic, you probably off the top of your head won't know the exact details of all of them. So just having something in your notes that's a useful map to guide you once you've got the question in front of you is a really thorough and strategic way of planning out your answer. And then once you read the scenario and you see there's advertising that seems to encourage people to come into the store, but then when someone goes into the store, there's not enough, you think, oh, that's bait advertising, or that might be bait advertising. And then you can go and look at your notes later and fill in the detail of that. So we talked last week about sort of having your short form notes and your long form notes. This is a really good instance where you can build up the quick and easy. Can I identify roughly what's going on? And then the more detailed, okay, now that I've got a sense of that, what are the specific things that I need to be thinking about, I need to be discussing? So a hopefully useful illustration of a broader concept or broader strategy in note taking and exam preparation there. Any questions about the ACL in a broad sense before we get on to the specifics of the tutorial questions? No, fantastic. Well, let's talk about some tutorial questions and pull out some of these ideas in action. So the first problem is that an advertisement is placed on the internet and it purports to offer nominal fees for access, free software, a free modem, and free software installation. And it states that conditions apply. There's no mention of large annual registration fees, prepayments, and annual registration fees and payment by credit card only. Is that conduct likely to contravene the ACL? And if so, in what ways and what remedies might be available? So brief initial reactions. And I suppose before we get too much into legally what's going on here, just a very surface level, put yourself in the shoes of the average consumer. what would you be your reaction to seeing an advertisement like this? What impression would you get?
I'd look at the wording of nominal fees,
Yep.
read all the entire package as representing only nominal fees.
Yep. So emphasis on this wording of nominal fees and beyond that, the connotation that it's probably a pretty low cost product. Yep. What else?
Wouldn't people tend to ignore the little fine print called conditions apply clause?
There's certainly the risk that they would. Yeah. Yep.
Well, I guess an average person would just see that essentially they're borderline being offered something for free. I mean, there's nominal fees, but you get free software, free modem, and software installation. It says there's conditions, but it doesn't say what they are. So it's on the face of it, it's basically, you know, this is an irresistible deal.
Yeah, yeah, and I mean this whole idea of, you know, if it's too good to be true, it usually is looms large in this space too. But yeah, certainly the repetition in the ad of free this, free that, nominal fees, it creates this impression that this is something that is a low cost product. Really good observation. Now let's extend that a bit more and start to think in legal terms. What sort of issues are we thinking might be relevant? Particular types of consumer protections that might be relevant.
Firstly, it's uncontroversial that the advertiser is a corporation and it's directed at consumers. So therefore the ACL applies. And if we're looking at section 18, subsection 1, that's the first provision that we're looking at. The companies and business providing internet access along with free software modem, software installation for payment, gives rise to a company acting in trade or commerce. The advertisement basically induces customers to enter into a contract for nominal fees for access to and internet access, free software modem, and software installation. It fails to mention that the large annual registration fees, prepayments, and annual registration fees, and also paying by credit card only. So that's one of the first things. Then I'm looking also at section 29, 1I and M in relation to making false or misleading representations about goods or services that a person, I won't go through it because it'll take ages to go through that.
That's all good. Let's focus on section 18 and the misleading and deceptive conduct in the first instance, and then we can expand out and think about if there's anything else as well that might apply. So you're right that this scenario should make you think about, is there misleading and deceptive conduct going on? Is it the representations that are being made are not consistent with what's going on, and so we're thinking about, is this conduct likely to lead someone into error, basically. So the thing I want to discuss in a bit more detail, though, is, for one, how do we decide if something is misleading or deceptive conduct, in the sense of from whose perspective do we judge whether conduct is likely to lead a person into error?
But the expected reaction from an ordinary or reasonable member of the class to whom the representation is directed?
Yes, absolutely. So we're focusing on I suppose the typical person from within the class at whom this is directed. And so in the broad sense, you're very right, Bill, in that this is directed at consumers, in that the intended person who'll be buying this product would be a consumer. But let's think in I suppose a bit more specificity. Who is this actually being targeted at? What class of consumer or group of people do we think this advertisement is aimed at?
Oh, sorry, you go.
Oh, sorry. Given that the advertisement is online, the people who are likely to see this advertisement already have an internet connection. So I guess arguably it's aimed at, it might be seen to have been aimed at people who want to convert from an internet provider to another in order to get a better deal than what they already have.
Yep. That's a really good point. Jason, what were you going to say?
Pretty much the same thing. I was just going to sort of say the class of people is very vast. You know, it's anyone using the internet and exposed to that particular ad.
Yeah, absolutely. So thinking about the use of the internet creates a really wide reach for the advertisement. And, you know, in today's society, it's difficult to find people who aren't connected to the internet. And so the potential reach is huge, as Michael says as well, because it's an ad that's online. It's aimed at people who are already sort of, I suppose, in the system, in the sense that it's internet services and products, but it's targeted at people who already have the internet in order to be able to see it. One thing that we actually, no, I'll open it up to anyone else as well. Did anyone else want to have any other thoughts on which sort of group might be targeted?
Yeah, I think it will be just as general as and broad as saying to the public at large. Because if we consider, that's probably a bit off topic, but if we consider the publication, like what it means to publish something, once it's published online, it automatically is possibly being read by everyone. So I think it will be, the definition will cover to the public at large.
Yeah.
There wouldn't be any need to go that far.
Yeah, that's a really good point. And I think as a baseline discussion point, just to say that the public at large is the target is a really good one. What we could do is add a little bit more to it and say that and in an exam scenario where you would have a hypothetical client and details about that client, that would also help you decide the frame of reference, right? If you're trying to establish that the person is within a class of people or not within a class of people, that will sort of help frame your arguments as well. But one thing that we might focus on is that the free modem, the free software installation, those sorts of things are appealing to people who are not especially sophisticated users. Sure, they would already have internet to be able to see it, but they're not necessarily a group of users who we would assume have a lot of sophistication in their understanding of the internet and how internet services work, because the installation process, that's it's not the most complicated thing anyway, and so having that offered as a free part of the service might be more appealing to a particular group of people who aren't especially, they use the internet to function in society, but they're not a group of people who are especially well versed in the industry, let's say. And so the reason why we might want to include that level of specificity and in particular downplay the level of sophistication of the target class or group is that then makes it more likely that the conduct is going to be misleading or deceptive to them, right? If we thought that the the group or class were IT people in the IT industry or something like that who've got a much more intimate knowledge of the industry. That's a class of people who you would expect would be a bit more cautious of, well, hang on, there's probably more to this story. Whereas if the target is people who are less connected to those issues, then the scope for misleading and deceptive conduct would be broader or easier to establish. But I think for the most part, considering it from the perspective of the public at large and sort of just a general person is a really great starting point. So we've sort of established roughly who the group or class of people to whom the conduct is directed would be. How do we then from there decide, okay, is this conduct misleading or deceptive? Does the Act actually tell us, or does the consumer law actually tell us what misleading or deceptive conduct would be?
No.
I thought it was undefined.
Yes, yeah, that's right. So how do we know?
We'd use analogous reasoning and find cases.
Yeah, absolutely. And well, so I suppose that the threshold standard would be to think about is the conduct likely to lead a person into taken as a whole, does the conduct have a tendency to lead a person into error? That's Chief Justice French in Campbell. And so then beyond that, what would be the sorts of things that we would be thinking about?
Well, I guess the most obvious was the fact that it said conditions applied, but they weren't stated anywhere at all. And the price that was associated with those conditions sounds quite significant. So that very significant part of the, I guess, advertisement wasn't stated at all, rather than just being, say, in fine print.
Yep. So it's missing a really key bit of information. Yeah. What else?
I think we might also need to have a look at case law as well. I mean, there's one principle I'm thinking of, silence, which was brought up in, I think it was Miller Associates v BMW Finance.
Yes. The silence is you're right in principle. Where that tends more to apply is where the consumer outlines their understanding or impression, and then the seller fails to correct that mistaken belief. So if you had someone go into, I can't remember if the facts say the company's name. No, they had a consumer go in and say, "Oh, yep, I'm really looking forward to signing up to this software plan. It's all free, and these nominal fees mean that this will be really cheap for me. I'm glad that there's nothing more to pay," or something like that. And then you would expect, or in order to avoid misleading and deceptive conduct, the salesperson should say, "Oh, well, hang on, there's these extra registration fees that you do need to be aware of," and at that point, the failure to say those things and correct the incorrect understanding, that silence could be taken as misleading or deceptive. But it's less about silence in the sense of what's not said in the advertisement itself. Does that make sense?
Yeah, certainly. I think I forgot to consider the fact that there must be a consumer that had an understanding that was never corrected.
Yeah, no, that's all good. So yeah, in this instance, probably not silent, but what else might be relevant?
I got two more things I guess I thought was like, it actually doesn't state any price whatsoever. If it's
Yep.
not, it just says it's a nominal fee. And possibly tangentially relevant is that generally software has sort of nothing to do with like internet connections. So it could be offering something that either, you know, is not really relevant or exists or something like that. You know, they could be arguing, for example, that they're giving you a modem with software that goes in that modem, but it's not really defined as software. It's defined as firmware.
Okay, yeah. Well, I think a broader point about having more information would help refine the answer is a good one,
Yep.
and it's especially relevant because misleading or what it constitutes misleading or deceptive conduct will be a question of fact, and so of course it's intimately tied to the facts of the scenario. Yeah, absolutely. That made me think of something else. Oh no, I was just gonna say that, you know, the free software might be like Zoom or something, which would have more of a connection to the internet. But yeah, that's a by the by, really. Yeah. Yeah, go ahead.
Question. Would that be an argument just saying that it's probably not misleading, but it will be within likely to mislead based on the fact that people might have to like click on the link, condition apply to find out what the price is, what the actual advertisement offer would that be? Like
Yeah,
they're not hiding anything on one hand, but on the other side, they are like kind of assisting you in, you know, getting the sale done. Like they're convincing you with all the free, the word free, but then at the same time they're telling you that conditions apply. So it's a balance of probably considering objectively, are they putting a link into the condition applied, that it's easy for people that navigates online and a reasonable person to get the actual conditions, or are they hiding that and then going on the path that they're hiding, you know, the truth to actually make the sale go. That's probably what I didn't find like a right straightforward answer. I just went both way.
Yeah. Well, and I think the emphasis on conduct that is likely to mislead or deceive is the right approach, rather than focusing on or trying to establish whether someone was misled or deceived. Obviously, that can have relevance, but looking at Chief Justice French in Campbell and Back Office, it's an objective test based on the state of mind of the relevant person or class, rather than a particular individual. So thinking in terms of whether the conduct is likely to mislead or deceive, rather than being specific and saying yes, this would definitely. I think that's a good approach. It's still good to try and come to a conclusion, even if it's tentative or subject to knowing more facts or something like that. Just thinking about cases and analogous reasoning, did anyone have a look at ACCC and TPG?
Yeah, I did.
Yeah, did you want to tell us a little bit about that one?
I guess sort of a lot of the facts seem somewhat analogous. TPG offered an internet service for a price which was displayed, but it not clearly displayed, but still it was there, was that there were extra fees. You had to buy an extra service. You know, there were large setup fees and a deposit, and that was held to be misleading, basically because the dominant message was the price and not those additional costs. And it said of importance was the fact that the only reason consumers it was about whether they would enter negotiations. And that was the misleading advertisement, and that was held to breach Section 18. So yeah, I kind of reason that, you know, the threshold is not actually that high. If you contrast what's happened here, the circumstances here are actually much more misleading than what TPG were doing, because they didn't advertise a price at all and didn't advertise the conditions at all. So it's actually, the conduct seems to be worse and more easily satisfied.
Yeah, absolutely.
Jacob,
And I mean,
wasn't
sorry, go ahead.
wasn't the threshold test of TPG whether they would enter into negotiations rather than enter into the contract itself?
Yeah.
As in, so is your argument then that because this advertisement is just going straight into the contract, it would be it could be distinguished from TPG? Or
No, it's analogous, but I think
Okay.
the High Court recognised, and I think that was mentioned in the High Court in the ratio, that it wasn't, the test was not whether they were entering into contracts, but whether they were entering into negotiations.
Yeah. So thinking about the it's not quite the idea of getting people into the room, but it's you're right that it's we're thinking about misleading or deceptive conduct being about the focus on the thought process and the, I guess, the decision making process of the consumer, or the likely class of consumers, rather than necessarily the actual substance of the contract itself. Yeah.
And then the other case authority was Murphy and Overton Investments.
Yeah. Do you want to tell us more about that one?
About the retirement village brochure represented at the outset that the budgeted projections for the costs of management and maintenance, which were incorporated in the appellant's lease, the retirement village operator represented that the estimated initial outgoings for their unit, which was stated at $55.71 per week. However, in the subsequent years, that $55.71, I think, had increased, the retirement village operator had increased those fees. And that was, I think, in the High Court, they did say that they misrepresented those fees, and it went. I think the final outcome was that the claimants had sued for damages on that basis.
Yeah. Well, and we can talk about the damages a little bit later, but yeah, just thinking about the factors that the things that get said, the things that don't get said. Just quickly before I forget, cycling back to TPG, the other part that I really want you to take from that case is to think about these ideas that the focus is on the dominant message, and that consumers shouldn't have to find their way to the truth. Those are factors that you'd argue have a lot of relevance to the current scenario as well, because for one, it's a broadly similar scenario in that it's advertisement for internet provision. But beyond that, we've got these similar ideas about the dominant message being, this is a low cost product, free this, free that, free this, nominal fees. The dominant message is, this is something that is not going to cost you a lot of money. And the gap between that dominant message and the truth, which is that there is this significant fee, that's where the discussion and the focus really needs to lie. And this idea that consumers shouldn't have to find their way to the truth. And, comparing, as Jason noted, at least TPG, consumers could find their way to the truth. They just shouldn't have had to. Whereas in this scenario, there's, on the facts that we've got, there's not even any evidence that even if they'd wanted to, consumers could have found their way to the truth. It's not clear at what stage of the process they find out about these large annual subscription fees and those sorts of things. So that's that needs to factor into the mix as well. If you
Just on
were,
that,
sorry,
Jacob,
go ahead. Yeah.
you're right. It does say about there that the conditions do apply, and a part of the whole consumer buyer beware is if there is that, one should be asking those questions, what am I actually entering into before they do sign that contract? It's one of those wishy-washy things, and I'm going back to contract law when I think about that, but it is one of those things that if you don't look into, and potentially, obviously you need more information, that is where all this other information will lie.
It's
And
like
as
you
I think
read my
Laura
mind.
mentioned, you could click on that link potentially, and it might have already brought that up. We don't know.
Yeah, I was literally about to say, if you were the internet service provider, or the company that's involved here, what would you say? What would you argue? And if you were, you would try to argue that this conditions applied line should signal to customers that they should be thinking about looking into it a little bit more. The difficulty with that approach is that that's what TPG argued in ACCC and TPG, and the High Court rejected that approach on the basis that following these same ideas around, they shouldn't have to find their way to the truth. Yes, you can't go in, you can't just completely bury your head in the sand. And again, this is one of those. This is why the focus is on the whether it's likely to mislead or deceive the ordinary person in the class, rather than, if you're how to put it diplomatically, atypically naive to things, then that's a problem, and the consumer law won't necessarily protect you. But that conditions apply and leaving it at that's still, compared with how overwhelming the dominant message is, that still leaves consumers to find their way to the truth. And that's the issue. And you could argue it, and people do argue, that the consumer law skews too far towards benefiting the consumer versus the traditional contract law position of caveat emptor, buyer beware. But a balance has to be struck somewhere, and that's where we've got. And so by analogous reasoning, the argument would be, sure, this company would say, well, we said conditions applied, why didn't they look? But it's unlikely that would be held to have been enough to avoid the impression that conduct is misleading or deceptive. But it's a really good point, and one that we've talked already about, making sure that you, in your answers, you're considering both sides. You're thinking about, okay, well, what might the other side argue, and if so, how would I respond to that? So absolutely thinking about, if you're the internet company, this is what you're going to try. And being aware to that, so that you've got the response ready to go to say, well, let's look at TPG. That's not going to fly. That's not going to cut it in this instance. Any other?
Yeah, I found a counter argument on my own argument, pretty much. Paragraph 50 of ACC and TPG says, it has long been recognized that a contravention of Section 52 of the TPA may occur not only when a contract has been concluded under the influence of a misleading advertisement, but also at the point where members of the target audience have been enticed into the marketing web by an erroneous belief engendered by the advertiser, even if the consumer may come to appreciate the true position before a transaction is concluded. So this paragraph would have killed my whole argument, like what I just said before.
Yeah, no, absolutely. And it's this, and it really highlights, you can see where Parliament intended. Yes, that's on Trade Practices Act, which was the predecessor to the consumer law, but um, both both directed at similar ends, and the idea very much is, you know, people are swayed by their initial impressions, and people don't readily change those impressions even when they're confronted with new facts and information. And so, yeah, having a set of protections that tries to guard against some of those issues as well is important. I might have frozen there.
Yep.
Sorry, everyone. I think I might have frozen then for a second.
Yep.
Sorry. So basically just looking at this idea that yeah, the consumer protections are trying to guard against misleading and deceptive conduct sort of at every point throughout the process and engagement with the consumer, because those first impressions, people's first interactions with the product can dictate their entire engagement, let's say. Any other thoughts about that one? Either arguing that it is misleading or deceptive, or trying to play devil's advocate and say that it's not misleading.
I think, should we draw the line here between section 18 and 29 a bit more finely? I mean, I'm looking at this case involving ACCC v Kogan, which is probably a bit more of an extreme scenario, because they advertised in such a way that they told people that if they didn't use this discount coupon, that they would miss out on a discount, when it actually turned out that they were never receiving a discount at all. I'm just thinking, how do I go about drawing this line a bit more effectively between the two?
As in thinking about representations versus conduct?
Yeah.
Yeah. So...
Oh, sorry, I'm probably referring to the wrong sections. Sections 18 and 21, which involves unconscionable conduct.
Oh, sorry, it's 21. Okay, yes, that's a good question. So unconscionable conduct relies on sort of the key idea with unconscionable conduct is the disparity between the parties. So thinking about some party being at a disadvantage, and then the other party knowingly exploiting that disadvantage. And it's not just let's say the usual disadvantage of a company knows more about their product than the consumer does, and so, you know, they've got a lot of they hold all the chips. The key thing is there's got to be a special disadvantage that affects the person's ability to judge what's in their own best interests. And so conduct that's misleading or deceptive, I suppose you can think about it in terms of the seller is ultimately trying to convince the consumer to buy the product or the service, but the consumer still at the end of the day is free to decide whether it's in their own interests to get that product or not. They might be mistaken about the substance of whether it is or not, but they've still got that rational ability to decide for themselves, you know, whether this is a good purchase or not. Whereas unconscionable conduct and thinking about special disadvantages, we're thinking about issues where there might be some kind of mental incapacity or English not being a first language, or well, not even just it not being a first language, but not having a strong grasp of the English language. These are the kinds of things that put someone to such a disadvantage that they're not actually in a position to judge what's in their best interests. And so that's when we're thinking about unconscionable conduct, it's knowing that there's this special disadvantage and actively seeking to exploit that. Does that make sense?
Yeah, certainly. I can see now that there was no real special disadvantage between the customers and, in this case, the internet provider in this scenario. There's a freedom to choose whether or not to take the product. I mean, the service.
Well, and it raises the distinction as well. Whereas we've talked about misleading and deceptive conduct being the frame of reference is the class of person to whom the conduct is directed, whereas the unconscionable conduct is directed to the special disadvantage that's unique to that consumer, right? So it's whereas misleading and deceptive conduct, we're thinking about, okay, it is the average person who would be seeing this, would they be fooled? Unconscionable conduct is what are the circumstances around this particular individual and their ability to judge whether it's in their interest or not to proceed.
I'd argue that a little bit. You could make that distinction depending on the information that you were to look for further, because it's quite vague, because you couldn't determine who that audience was made out to. If that people with a disability have access to the internet, and if they hear free, and it's a click of a button, well, then that definitely could be unconscionable, potentially.
It could be both, but you'd be where the distinction would lie is between
it's going to come back to circumstances.
Right. So
provided. That's what I'm saying, though, that you see a connection of the two joining together, depending on the information provided, is what I'm getting at.
Okay. Yeah. Absolutely. You know, you could
more
have
misleading, but it could definitely have that second layer as well of unconscionable as well, if they were looking to promote it within a disability sector where those people would have free access or easy access to a computer, to the internet, free for all on a game. That ad pops up. Oh, look at this. This looks really cool.
And and I think that as a broad thing, yes, absolutely, you can have both. But then specifically thinking about, what extra facts would we be looking at in this scenario that would lead us to that conclusion? Yeah, it would be some sort of direction at, it's so simple. It's targeted at this group of people who don't have the capacity to set this up for themselves and all those sorts of things. Absolutely.
Yep.
Yeah. Ahwara, you wanted to say something as well?
Yeah, just on the extreme of what Angela said, then if we were arguing in the favor of Google, for example, in the case of Google and LLC, they will argue that a snippet, it's not something that is authorized. So it's not a mere, so it wouldn't satisfy the enticement of a person. So that will probably be struck down by this case, that it wasn't actually, they didn't have any authority to publish that material because it was just like a snippet from another website. So Google doesn't actually have authority of making things popping up for people to see it. That was what the whole case was about. But that would have been on the extreme part, arguing in favor of a website sort of thing.
Right. So if I understand you right, and again, this is in the context of where we're adding facts to a scenario that's a bit lighter on facts than you'll get in the exam. But say the scenario was, we've got this general online ad, and then our specific hypothetical client is let's say it's an elderly person in a nursing home saw that and for some reason decided, we've got to have this. And so the company might say, well, we couldn't control that it appeared on the nursing home computer or something. I'd have, my concern with that argument would be that the reason why Google can get away with that is because they're just the platform, whereas a company making a specific ad that's intended to bring consumers in, they've got to know, if I'm putting this on the internet, anyone could see it. So I'd say that there's probably a distinction there, but I take your overall point. Yeah. Cool. Well, we're rapidly running out of time, but I think it's very much well worth thinking about the ins and outs of misleading and deceptive conduct, and the ways that we can be thinking about how it applies. Let's talk about remedies. Let's say that that this is misleading and deceptive conduct, and I think that we'd have a pretty strong argument there. What might the remedies be in this instance, or what might the next steps be?
When you claim under Section 236 for damages, if a person suffers loss or damage because of the conduct of the company, contravening either Chapter 2 or 3,
Yep.
And also maybe an injunction to stop the company from, under Section 232 of the ACL, to stop the company from taking action against a person who would breach the contract if they discover that they were misled.
Yeah, absolutely. So broadly, what we're thinking about here is who's affected or who's potentially in a position to take action. So if we're in a scenario where we've got a hypothetical client who has suffered some loss, then Section 236 damages certainly arrives. If like in the scenario that we've got, we don't actually have a specific person who has been affected or that we know has been affected, the ACCC still has power under Section 218 to take action. Sort of broadly, that's the empowering provision. And then, as you said, Bill, Section 232, the power to seek an injunction to actually try and mitigate the issue and prevent loss or damages arising from the misleading or deceptive conduct. So just thinking about who's in a position to do something, and being able to recognize that there's the I suppose the remedies that attach to the individual, and then there's the remedies that the ACCC can take that are let's say more preventative, and the reason that's important, when you get a chance to look at the practice exam question, it sort of talks about the ACCC is looking at doing things. So we're not necessarily just thinking about how does this affect the individual client. We're also considering these broader regulatory bodies and the actions that they might be taking in the space as well. And in this particular scenario, without an individual client, but without being able to tell exactly what loss they've suffered, it's tricky to calculate exactly what those damages might be, as in terms of amounts, but very much good point to recognize that would be the remedy. Any further questions on that one? No? Fantastic. We'll just very, very, very briefly whip through problem 2, which has a corporation which is in the business of providing casual administrative staff to other businesses, advertising a series of job vacancies in order to expand the pool of available employees. The corporation currently actually has no jobs waiting for applicants, advise the corporation. So here would be thinking about section 31, which relates to a person must not in relation to employment engage in conduct that is liable to mislead persons seeking employment as to the availability, nature, terms or conditions of the employment. So that would be the suggested starting point there, and then you could have a discussion around whether what's been advertised is likely to mislead and those sorts of things. Appreciating that we don't really have time for a detailed discussion of that one. Did anyone have any burning questions or issues that they'd like to clarify in relation to that one?
I think you just dropped out there, Jacob, before. So all I got was the first little bit, and then you come in at the very end of what you said. So I don't know how much in the middle there was.
Oh, okay. Sorry about that. So basically, I'm suggesting for question 2, you'll want to look at section 31. And if there's any specific questions or things you wanted to clarify about that, we can quickly deal with them now, or you can send me an email afterwards. What I'd like to, I guess, suggest in closing, because I think if it's not a question now, it's definitely a question that will come up in a few weeks' time, about how much do you need to know about all the other different types of consumer protections, and you know, the list of unfair practices, and all the different sorts of consumer guarantees, thinking around section 54, 55, etc. And my suggestion is that you pay as much in preparing your notes. My suggestion would be that you keep your, let's say, study proportionate to the level of detail that they're described in the study guide and the lecture guide, in that misleading and deceptive conduct clearly has a lot more focus given to it than a lot of those other sections. And that's not to say that the other sections are completely irrelevant, or that you don't need to know them. You need to know them, and you need to be aware of them because they might apply. But in terms of what's the level of detail that you need to be thinking about these different sections, very much be guided by the level of detail that's attached to them in the study materials. And I don't know how much more of a hint I can drop, but that's, you know, take of that what you will. Any final questions or comments before we wrap up this afternoon? No, fantastic. All righty. Well, we'll leave it there. Thank you all very much for coming along this afternoon. We'll be back next week to talk about competition law, which is in some ways flows on from consumer law in that it's derives from the same act and is broadly focused on the same objective of making life better and easier for consumers, but that has let's say a greater regulatory focus on the actions of corporations in relation to one another. So looking forward to that discussion, and I'll see you all next week. Thanks very much. Bye.
Thanks, Jacob.